some of you, I think I have 4 at this point, on the sample question that I sent around. I'm not going to talk about it at all, and I hope you won't either at this point, because I did ask or suggest that if you want to do it, you can do it without having seen it first. And that would give you the most realistic experience mirroring what you'll do on the exam. So I'm certainly not going to talk about it with those in class, at least for those of you who've done it, to protect those of you who haven't yet. But I will get you answers back as quickly as I can for those of you who've done them, and get you some comments and so I've gotten them, and that's a good start. Okay. Anything else? Going once. Going twice. Felony murder. This will complete our discussion of homicide. I used to do a lot more felony murder, but I don't have time with other things we want to cover, and it's not as important for reasons that we will discuss to most of you. But it is important to sort of see the concept and put it in context of the rest of our consideration of homicide, because it's certainly not irrelevant. It's less important, but it's not irrelevant. So what happened with Martin? What happened with Martin that gave rise to this charge of felony murder in New Jersey?
So the defendant, Martin, and 4 of his friends they were from Seaport, went to a party hosted by Louis Baker. So the defendant stated that before he smoked marijuana and he drank, and then went to the party and he drank more. And when they were at the party, one of his friends, Paul Wade, got into 2 fights. One was with Mike Kilpatrick. And then after the second fight, the hostess told the group that they had to leave. So when they were leaving, the defendant and Wade vandalized a motorcycle that they thought belonged to Mike. And then 15 minutes after they left, someone noticed that the building was on fire.
Just a coincidence.
Yeah. And everyone escaped except Barbara Quartz, who had passed out, and she died from asphyxiation due to smoke inhalation and carbon monoxide intoxication.
So how did this not so coincidental fire start?
According to the defendant, he was leaving and he found a bag of trash and was kind of just throwing it around making a mess. And he lit a cigarette with a match and then lit the bag on fire, just thinking that it would go out.
I love when this happens. Alan, open the envelope that you are holding. Cigarette. Now, how many of you think that she just innocently said the word that just happened to be in the envelope that she was holding?
Not me.
What was that?
She cheated.
She cheated.
X-ray vision.
So how many of you think she cheated?
I'm just
Be your own.
You know what? You know the old saying, the person closest to you knows you best. All right, we're going to just give you the benefit of the doubt and assume that that was completely innocent. All right, he lights a cigarette. This is his version of events. Spreads trash around, lights a cigarette, and
Lights it on fire.
lights it on fire. He thought it wasn't going to spread. Maybe it would burn up the garbage, make a smell, make a stink. And that was about the size of it. He said he didn't want to cause a fire that would spread or catch or anything. And if you were the prosecutor, Ms. Allen, what would you say about that?
That any reasonably prudent person would know that you locked that on fire.
Is that just speculation on your part? Is that just, are you just going to get the jury to with no evidence of anything else on his part?
Well, no, they had a fire insurance investigation.
Who said what?
She said that the fire was started by kerosene being spread between the ground floor and the second floor.
And what is that? And how does that support your case, Ms. Prosecutor?
it's arson intentionally.
If he had the intent that it wouldn't spread, is that consistent with putting kerosene around the whole thing? What is that? What is an accelerant, right? It's gonna make it more likely, if not inevitable, that this fire is going to spread. So the prosecution has some evidence, by that of the expert testimony, that kerosene was present, that it was present, that it spread, and that this shows that he's lying, that his version of events is not true. And again, the jury would have to decide, do we believe that? Do we think there's sufficient evidence of kerosene? But it certainly would be a basis upon which the jury could find that he definitely intended to set this fire, and with a more malicious intent than his own testimony would suggest.
So even if there was evidence of the kerosene, did
Yeah.
the prosecution not also have to prove that he put the kerosene there? Like, what if someone else did it and, you know, it happened to be there and, you
Mr.
know?
Wanda, you're the juror. You're a juror. There is a fire that he admits he started,
Mhm.
and there just happens to be kerosene. Do you think that those two are unrelated?
I have doubts. Like, it's not beyond a reasonable doubt for me.
Okay. We would fight in the jury room. I would be like, those two clearly go together. It's not just a coincidence that when this fire was set, there was kerosene involved, and that the kerosene helped to spread the fire, right? And I would infer from those circumstances, because you're allowed to draw inferences. The prosecution's not entitled to any presumption on this, but we can draw inferences about how that this fire was set, that it wasn't just the garbage and it wasn't just the cigarette, it was also the kerosene which caused it to spread, and that he was responsible. So we might differ, and that's how juries try to work out their decision in a case. For me, if I accept the prosecution's expert, and that's a different matter, if I accept that testimony that there was kerosene, that whatever chemical tests were done, etc., maybe based on the pattern of how it spread, if I accept that testimony, I have no trouble attributing it to Mark. That's just me.
So he just carried kerosene, like.
He found
just
it
had
on the
in his
site.
car.
He found it there, right? He doesn't have to have brought it there to have used it, right? But, you know, soul of the defense lawyer. Or a very discerning juror. Either one is good, okay? So he's convicted of arson. What else, Ms. Allen?
Felony murder and aggravated arson.
Aggravated arson, it becomes aggravated by corpse's death, and felony murder. And he appeals from this last verdict, challenging the jury instruction, okay? But we're gonna go through that, but to get to the jury instruction, we're gonna have to sort of march through some steps. And we begin with what the New Jersey statute says is required to impose culpability for felony murder. So what does the statute say?
The statute says that, the new statute,
The statute at issue here, 11-3A3.
oh, that says that if you're engaged in the commission of an arson.
Well, it's not just arson. Arson is one of them.
Or robbery.
Right, if you're engaged in much better. Commission what? Of
Arson, robbery, sexual assault, burglary, kidnapping, carjacking, or.
And we'll just say as a general matter, any one of the listed serious felonies okay? You're engaged in the commission of any one of the listed serious felonies, of which arson is one, and but we're gonna mark that as something that's gonna be significant to the character and definition of felony murder, okay? And
In the course of such crime, any person causes the death of another.
any person, what does that mean for, let's say, Wade?
Well, he can be convicted too.
Even though
he wasn't the actor specified.
right? So it can be any person. So any person,
Causes the death of another.
in this case, it's Martin who causes the death of Courts, but it can be anyone, right?
Other than one of the
Other than,
one of the participants.
and this varies from state to state. Some felony murder rules say just anyone. Others say, no, the death of a participant doesn't count. And they're thinking of the sort of paradigm situation where you have an armed robbery of a store, and let's say the clerk or a police officer shoots one of your co-felons, right? If the death that's involved is of somebody who's participating in the serious felony, in many states that have the felony murder rule, that death does not trigger culpability for felony murder. It has to be a death of a non-participant, a police officer, an innocent bystander like Courts, etc., a quote-unquote victim. Okay, so you'd have to know your particular statute to know whether it includes this, that it precludes using the death of a participant in the felony as the basis for felony murder. New Jersey has that provision, not a participant, whatever.
And then there was an exception. There's a list of
Exception, and that's going to be important to the way the court looks at this. And the exception has a bunch of ands, right? What does that tell you that it has a bunch of ands between the subparts of the exception?
that it has to be all of them?
It has to be all of them, right? It's not enough if Martin can show that just one of these applies. So what has to be true in order to satisfy the exception?
Like there can be all of them.
Well, tell me what they are. We're going to go through them one at a time and decide, does Martin meet all of them?
So the first one says that he did not commit the homicidal act or in any way solicit, request, command, importune, cause, or aid the commission thereof.
Does Martin meet that? No! Martin committed the homicidal act, which was,
Arson.
I'm sorry?
Arson.
Which was burning and causing Courts' death. Right from the very first element, all of which must be satisfied because there are ands, Martin loses. The exception does not apply here. Did anything about this decision and the way it was reasoned puzzle you when it comes to that fact that the exception does not apply? Anyone? What would you normally think would mean in terms of the way the court would reason, the way the court would decide the case, the way the court would explain its decision? What would you conclude from the fact that something like an exception or some part of a statute doesn't apply?
Seems like that would be the justification. I mean, you wouldn't have to justify it any further, that would be enough, right?
And what would in this case, the exception, what would be its significance to the rest of the decision, or to the justification for the decision, or the court's reasoning? Once you've decided that it doesn't apply, what should happen to it?
It's no longer viable.
It's no longer relevant. Does the court treat it as irrelevant? No, the court talks about it at length and says, we're going to use this exception in how we interpret the statute. That's your first clue that the court has an agenda, right? The court has a strong agenda here. And what do you think that agenda was? What did you get from the New Jersey Supreme Court's reasoning? It is extraordinarily hostile to felony murder, right? And one clue of that is that they use this exception, which does not apply here, as a basis for their interpretation, not of the exception, but of the whole coverage of felony murder itself. Look for those clues about what is behind the court's reasoning, what might be suggestive of its point of view, because it will tell you a lot about how to understand the case, okay? And the rest of the exception is you didn't commit the actual act, you were not armed with a deadly weapon that was capable of causing death or serious physical injury, you had no reasonable ground to believe that your co-participant was armed with a weapon, and you had no reasonable ground to believe that any other participant intended to engage in conduct likely to result in death or serious physical injury. So the idea here is, let's take our example of an armed robbery, right? You tell your co-defendant before you go to the liquor store, make sure not to bring a gun. That can only get us in trouble, right? And make things worse. We need the money. We're gonna pull this off, but don't carry a gun, right? So you're not armed. You don't have reason to believe your co-defendant is armed or is likely to commit an act of that would cause serious physical injury, and your co-defendant then, despite your wishes, has a gun and kills the clerk. So you didn't commit the homicidal act. Right? That's the idea of the exception. You're not innocent because you participated in a robbery, but you're not liable for the death under the felony murder rule. But that doesn't apply here. Okay? So how does does Allen view felony murder in terms of the nature of the crime? What kind of crime does it say felony murder is?
Well, it talks about it being a strict liability crime.
Good. The court says, and I want you to think of this in terms of, there's two different ways you can think of felony murder. Okay? One is this idea that it's a crime of strict liability. Because you don't have the intent to kill, so you're being held liable for murder, even though you lack the mens rea of murder. What's the other way you can look at that? What's the other way?
It says in common law that it transfers the intent, like the intent to commit arson to the intent to commit murder.
So the idea, one is, okay, you lack the intent, so it's a crime of strict liability. The other is, it's not that you lack the intent, but we're going to use the intent to do A, serious felony A, serious felony, in this case arson, and hold defendant liable for another result of that conduct, murder. Okay? When you see this, what immediately comes to mind? Nothing.
Is it that boat?
What?
Is it that ship that burned
That
down?
ship, that boat, that case, which was Faulkner. How many times did I tell you Faulkner was going to keep coming up throughout the semester? I keep my promises, I swear I do. This is Faulkner, right? Defendant intended to commit the serious felony of stealing the rum, and the state, the Crown, tried to hold Faulkner liable for another result, the burning of the ship. And what did the court say in Faulkner?
That you can't use transferred
You
intent.
can't use transferred intent. So whether or not you think of felony murder as a crime of strict liability or as a crime of transferred intent, I tend to like this more. I think this is a more accurate rendering of what felony murder is all about. Whichever you think it is, it's an exception to a very strong general principle in the criminal law. Right? The criminal law for serious felonies does not like strict liability, and it certainly doesn't like transferred intent, but either way, take your pick of what you think it is, felony murder stands as an exception to that rule. a very long-standing exception, very embedded in the common law and in many statutes, but an exception nevertheless. The New Jersey Supreme Court says this is the right way to think of it, and we don't like it. And so we're going to construe it narrowly. We're going to construe the exception broadly, and we're going to say that that reflects the legislature's desire to limit felony murder, even though the exception doesn't apply here. And because it's a crime of strict liability, and the code also suggests that crimes of strict liability should be construed narrowly, we're going to use those as our tools to cut back on felony murder. Okay? But even if you think it's this, which is what I think it is, that too could be a reason you could construe it narrowly, because that's a departure from general criminal law principles, the use of transfer intent. Okay? So what does the court do next? What does the court say about causation? What does the court say about causation here? Is sort of our next step in understanding the court's desire to limit felony murder. What does the court say about causation?
They said that they don't want the deaths that are too remote to count, so only but for causes wouldn't be enough.
But for causes would not be enough. The element of causation has to be that the conduct is a probable consequence of the actor's conduct. Okay? Must be a probable consequence. We don't want to transfer intent or impose strict liability for sure, unless, for example, death would be not just the consequence of the act, but a probable foreseeable consequence of the act. Okay? So what does the state argue about this issue of foreseeability? What does the state argue about foreseeability here? What would you argue if you were the state and it was a question of foreseeability? It's called?
Lighting a fire, it's foreseeable that it would set everything on fire and kill.
But that's not the result we have to say was foreseeable. What was that last part?
And kill somebody.
What else would you bring in the facts to argue foreseeability rather than just generally saying if you set a fire, it's foreseeable somebody could die?
They knew that the apartment was crowded and there.
Good, right? You want to use every fact at your disposal, right? What you want to do always is say, here's my fact board. Here are the facts in the case. Many facts as you think you can prove. And here is your legal conclusion that you want the jury to reach, that you reach that legal standard. So the court is saying it must have been foreseeable death from the arson. So every fact you can use to support that. Fire is deadly, or can be. That supports that. You're going to ask the jury to draw that out. That Martin knew the apartment was crowded. So he can't say, well, I didn't think it was unoccupied. Somebody who sets fire to a building they reasonably thought was empty has a very different argument when it comes to reasonably foreseeable, right? So you use the facts you've got to support the idea that the legal conclusion is met. So that when the judge tells the jury, ladies and gentlemen of the jury, you must find beyond a reasonable doubt that it was reasonably foreseeable for the defendant that the defendant's actions would cause a death. You as the prosecutor then get up in your closing and say, what, ladies and gentlemen of the jury, the judge just told you that Corpse's death had to be reasonably foreseeable. You shouldn't reach that conclusion because fire is deadly and it's foreseeable that if you set a fire to an apartment building, somebody could get killed, and not just any apartment building, but one here that the defendant knew was occupied and crowded. At least one unit in the building was, and maybe more. that knowledge is enough for you to draw that conclusion. Well, if that's true, Ms. Allen, why doesn't the conviction stand?
Because it's too remote.
Because what?
Too remote.
I don't think it was too remote. Ms. Mwanga might disagree with me, but I don't think is it about whether it was actually too remote? Remember, what is Martin challenging?
Jury instruction.
Jury instruction. So we don't know if it was too remote, but the jury has to be given the opportunity to consider the case, right? So the instruction should say, ladies and gentlemen of the jury, if this outcome, the death of course, was too remote a result of setting the fire, then you should find that it was not foreseeable. So because we didn't have that jury instruction, this conviction can't stand. This conviction can't stand. In my view, I would have said it was harmless error. I would have said that it was eminently foreseeable and not remote, and that no reasonable jury on these facts could have concluded that it was too remote, but the court doesn't agree, and it sends the case back. Just a couple of policy arguments. As you can see, this opinion gives you a really strong sort of view of the weaknesses or the case against felony murder. I want you to sort of see some of the counter arguments so you can see how both sides could argue it. I think there are some justifications for it, some pretty powerful justifications. That if you have the felony murder rule, it can influence behavior. When you're committing one felony, you may have a choice about how you commit it. And some ways in which you commit your felony could be more dangerous than others. And if you know you might be culpable for the death that results from your more dangerous choice, it may lead you to safer choices and thus avoid deaths, okay? And the second argument, I think, in favor of felony murder is that results count. Remember, we talked about the significance of harm, and that in some jurisdictions, we punish attempt less than we punish the completed crime. Well, if results count, then Martin's act of arson had worse consequences, worse results than somebody else's arson who, fortunately, no one died. You might say that's just dumb luck, but our law embeds that into our criminal justice system, okay? So those are some of the arguments in favor of a felony murder rule. What about Kentucky? What does Kentucky say about felony murder?
Kentucky doesn't have felony murder?
Kentucky does not have felony murder. That's exactly right. Right? Kentucky Supreme Court has held that the current modern structure of the KRS has essentially eliminated felony murder as an independent category of murder. Right? You can search anywhere you like in the KRS, right? The chapter we looked at for homicide, and you will, in 507, and you will not find any mention of felony murder. What we do have is wanton murder. In Cruz, K-R-U-S-E versus Commonwealth. That's 704 Southwest 2nd, 192, if you want to look at it. 704 Southwest 2nd, 192, from 1992. The defendants had robbed a Western auto store of numerous guns. One of the defendants shot 2 employees in the head, killing one of the employees. There was evidence that they had planned the robbery in advance, and they had consumed a considerable quantity of alcohol and Quaaludes prior to the robbery. It's always a great case when you can bring Quaaludes into the situation. In their instructions, the trial court told the jury that the non-shooting robber, obviously the shooting robber, you have no problem convicting him or her of murder, but the non-shooting robber could be guilty of murder if, quote, by so conspiring to commit this robbery, he was wantonly engaged in conduct which created a grave risk of death to another. Sound familiar? Wanton murders. The definition of wanton murder. Created a grave risk of death to another, and that he thereby caused the death under circumstances manifesting extreme indifference to human life. I mean, that is word for word the provision of the wanton murder statute. Okay, tracks 507.020. But it doesn't hold the defendant, Cruz, liable for the murder simply because he was committing a felony. So the committing of the felony can be the basis for finding wantonness, but you have to find wantonness. Here's what the Supreme Court said, the Kentucky Supreme Court. Before the enactment of the penal code, the current penal code that is, it was universally held that when a homicide occurs during the commission of some other felony which involves a substantial risk of bodily harm to the victim, we pause here to note, that is where we get serious felonies. They are dangerous felonies, those that involve a risk of serious bodily injury or death. Okay? And the court notes that. The court says it was held that if you were engaged in a felony which involves a substantial risk of bodily harm to the victim, all who participate in such other felony are equally guilty of the homicide, regardless of who does the killing. The intent to commit the underlying felony supplies the element of intent to murder. Okay? Instead, with that gone, the key question is, does the commission of the felony amount to the wantonness, and does it show the extreme indifference to human life necessary for wanton murder? So that's what you instruct the jury. You don't do the causation instruction. You don't say, was it probable, right? You say, like any other wanton behavior, did the participation in the felony amount to the kind of wanton conduct that created a great risk of death and showed extreme indifference to human life? If it didn't, then it's only second-degree manslaughter. Okay? Questions? About homicide in general? Yes, because the instruction that I read you was exactly on track with the wanton murder. Okay? Yeah.
You said if it didn't, then it was manslaughter?
I think, right, if the participation in the felony, by whatever participation the defendant had, did not amount to wanton behavior that created a grave risk of death, or if it did not show extreme indifference to human life, then it would only be second-degree manslaughter. Okay? Because you'd be wanton, potentially. Now, that's assuming the prosecution can at least show wantonness, but it didn't create a grave risk. Let's say, for example, that your only participation, Ms. Clements, we are part of a gang that robs banks, and your only participation is to pick out the banks. You have some skills in creating algorithms, and you can try to make it look like we're selecting our locations randomly, and you never even go on one of these robberies. You don't supply any of the weapons, any of that. The jury might well find that you didn't show extreme indifference to human life. So even though you participated and were part of the commission of the felony, that participation doesn't rise to the level. Maybe you can find it wasn't wanton. If they found it was wanton, they might show, well, you didn't create a grave risk of death to human life. They might even find that if you drove the getaway car. Again, up to the jury, did your behavior rise to that or fall to that level? Okay. Now, if you were in the bank lobby holding a gun and were a mask and had a mask over your face, and one of your co-conspirators was one who shot the teller, I think you're in trouble. Okay? All right, that's going to finish us on homicide, not just felony murder, but homicide in general. So, questions before we start on group criminality? All right. There are two things we're going to talk about for the most part when it comes to group criminality. One is complicity, one is conspiracy. What's the difference?
statute after it's expired.
No. Complicity might be that, but it's certainly not what marks it, right? That is, it might be that you didn't do anything to stop it, but you might have done a lot to aid it. You might, in other words, it's not a matter of affirmative acts. Something else.
Would an example be Mary Surratt versus the actual conspirators who planned to murder Lincoln?
That'd be an example. Might be an example. Who wants to be our prosecutor? Who's gonna be a prosecutor? Webb. If you think that someone, let's say Mary Surratt or anyone else for that matter, is complicit in a crime, what are you going to charge them with?
Failure to act.
No. What are you going to? That's maybe the basis for the charge. Again, it might be a failure to act, or it might be an affirmative act that aids. But what are you going to charge them with?
The crime itself.
The crime itself. Here is one of the key differences between complicity and conspiracy. Complicity is not a crime. It's not something you can charge someone with. Oh, I'm going to bring one count of complicity. Right? If somebody is complicit, complicity is the basis, whether it's aiding, whether it's refraining from action, whatever it is the basis for charging a crime. So what would Mary Surratt be charged with, Ms. Hart?
She was charged with aiding in the conspiracy to murder.
Well, I don't want to get into conspiracy right now. From what you just said, you just told me that those are different. Complicity and conspiracy, and gave me Mary Surratt as an example.
She was charged.
What would she be charged with? What would you charge her with?
I know that
We
she
can't charge her with complicity. What would you charge her with?
conspiracy, even though it doesn't.
Put conspiracy out of it. What did you say she was involved with?
The plan to assassinate Lincoln.
So she would be charged with in terms of the substantive crime.
Assassination of the president.
What would the crime be?
Assassination.
Murder. Right?
Technically also treason because it was the president.
Treason, good, fine, absolutely. Right? Is a basis for charging a crime. You are complicit in what somebody else did, and so you can be charged with the crime they committed, whether it's murder, whether it's burglary, anything, etc.